In Vietnam's rapidly developing economy, information is power. Companies invest years in developing client lists, pricing strategies, manufacturing processes, and technology systems. But all of this can be lost if an employee walks out the door and shares it with a competitor. To prevent this, global companies rely on non-disclosure agreements, NDAs, and non-compete agreements, NCAs. However, under Vietnamese law, these agreements must be drafted carefully to be legally valid. Clauses copied from foreign jurisdictions rarely meet Vietnamese enforceability standards. Understanding how NDAs and NCAs function under the Vietnamese labor system is essential for employers who want to protect their business assets effectively. Vietnam's labor code does not explicitly regulate non-compete clauses, but it allows employers and employees to agree on confidentiality and intellectual property protection. Meanwhile, the Civil Code and the law on intellectual property provide a parallel legal foundation for safeguarding trade secrets and confidential information. NDAs and NCAs are enforceable if drafted within the boundaries of the law, reasonable in scope, duration, and territory, and directly tied to legitimate business interests. While NDAs are generally accepted as part of labor contracts, NCAs are more sensitive because they restrict an employee's freedom to work. A non-disclosure agreement in Vietnam must clearly define what information is considered confidential. This includes trade secrets, financial data, customer lists, marketing strategies, pricing structures, and proprietary technology. The agreement should specify the employee's obligations to protect that information during and after employment, and the consequences for breach. NDAs can be signed as a standalone document or included as a clause within the labor contract. Employers should also include confidentiality obligations in their internal labor rules, ILRs, ensuring consistency across all policies. To be enforceable, the NDA must be in writing, signed by both parties, and ideally bilingual when one party is foreign. Non-compete agreements, NCAs, are more complex under Vietnamese law. They are not explicitly regulated but are generally recognized under the principles of freedom of contract. However, enforcement depends on whether the restrictions are reasonable. A valid NCA must define a clear duration, typically within a reasonable period such as 6 to 24 months, a limited geographic scope, and specific restricted activities. It must also include compensation for the employee's post-employment restriction period. Without compensation, courts are unlikely to uphold the agreement. Employers should focus on protecting legitimate interests, such as client relationships, trade secrets, or key technical know-how, rather than imposing broad employment bans. Many companies in Vietnam make critical errors when drafting NDAs and NCAs. The first mistake is using templates from other jurisdictions that impose unlimited restrictions. The second is failing to provide compensation for non-compete periods. The third is neglecting to translate the agreements into Vietnamese. Courts will only recognize Vietnamese language versions in legal proceedings. Another common issue is including overly vague definitions of confidential information, or competition, which makes enforcement impossible. Employers must ensure these clauses are specific, measurable, and relevant to their industry. Vietnamese law protects both the employer's commercial interests and the employee's right to work. Overly broad restrictions are considered unreasonable and may be invalidated. Employers should therefore balance protection with fairness, for example, restricting only direct competitors or similar roles within the same industry. The law favors proportionality. A well-drafted NDA and NCA protect legitimate business interests without infringing on employees' livelihoods. LTS law's approach is to design agreements that meet this balance while remaining enforceable under Vietnamese legal principles. To make NDAs and NCAs enforceable, employers should follow 5 key practices. First, define confidentiality and competition precisely. Second, limit the duration of post-employment restrictions. Third, specify compensation or benefits provided during that restriction period. Fourth, include Vietnamese as the governing language and Vietnamese law as the applicable law. Fifth, ensure all employees are aware of and sign these agreements before starting work or upon promotion to sensitive roles. LTS law recommends integrating these documents into onboarding and HR compliance frameworks to create consistency across departments and subsidiaries. In Vietnam, enforcement of NDAs and NCAs usually occurs through civil court or arbitration proceedings. Employers must prove that the employee breached confidentiality or violated competition restrictions, causing measurable harm. Documentation and evidence, such as signed agreements, records of data access, and communication logs, are crucial. In practice, most disputes are resolved through negotiation or settlement when agreements are clearly written and supported by evidence. Employers who maintain strong documentation systems are better positioned to protect their rights. A multinational IT company in Ho Chi Minh City once discovered that a senior engineer had joined a competitor, taking client data and source code. The company's global NCA was invalid under Vietnamese law because it lacked compensation and Vietnamese language. LTS law was engaged to design new localized NDAs and NCAs that complied with local regulations. The revised documents limited restrictions to 12 months, offered a monthly compensation, and defined confidential information precisely. Since implementation, the company has prevented further breaches and strengthened its internal legal defenses. LTS law provides bilingual drafting and legal advisory services for NDAs and NCAs in Vietnam. We help employers identify key positions that require confidentiality agreements, design compensation frameworks for non-compete restrictions, and ensure every clause is enforceable under Vietnamese law. Our team combines deep legal expertise with practical business insight, allowing employers to protect intellectual property, trade secrets, and competitive advantages effectively. Whether your company is in technology, manufacturing, or services, we tailor agreements to your operations and risk profile. In Vietnam, confidentiality protection is not automatic. It must be built, documented, and registered through enforceable agreements. A single leak of trade secrets or client data can cause irreparable damage. The right NDAs and NCAs safeguard your business, reassure investors, and ensure employees understand their responsibilities. If your company currently uses foreign templates or outdated clauses, now is the time to act. Contact LTS Law today to draft, review, or update your non-disclosure and non-compete agreements. Protect what you've built, stay compliant, and operate with legal confidence in Vietnam's competitive market.